Welcome back to our final panel on cybersecurity, climate, private funds, ESG, SPACs, and more. The SEC's active rulemaking agenda and its impact. So with us we have moderating Britt Whitesell Biles, who's a partner in the business litigation group in the Washington, D.C. office of Womble, Bond, and Dickinson. Britt served as Assistant Chief Litigation Counsel in the SEC's Division of Enforcement in D.C. Lauren Cook Jackson is counsel in the D.C. office of Gibson, Dunn, and Crutcher, where she practices in the firm's financial institution, securities regulation, and corporate governance, securities enforcement, and investment funds practice groups. Luke Tenery is a partner with StoneTurn and a certified Chief Information Security Private Security Officer. Prior to joining StoneTurn, Luke founded the global cyber practice and cyber response investigations and intelligence practice of an international consulting firm handling a range of active and emergent cybersecurity threats. Laura Vartain is chief of the National Security and Cyber Section of the U.S. Attorney's Office for the Northern District of California. And finally, Kristin Snyder is litigation partner at Debevoise and Plimpton and is a member of the firm's White Collar and Regulatory Defense Group. She's based in the San Francisco office. And prior to her role at Debevoise, Kristin served in the SEC's San Francisco office for 18 years, including as the Deputy Director of the Division of Examinations and a branch chief and senior counsel in the Division of Enforcement. So thanks so much to our panel, and I'll turn it over to Britt.
And you know what, Britt, I say just to mix things up, maybe I'll moderate. Is that okay with you?
Yes, it was like a great idea.
Okay. We want to keep everybody on their toes since we're the very last panel of the day, and we are standing between you and happy hour. And we're also talking about rulemaking and about 12 different topics in rulemaking. So I think we'll dive right in, and we'll start with cybersecurity. And I'd love to just... We talked throughout the day today, I think, just around enforcement and just aggressive enforcement in a number of different areas. We're going to be talking about rulemaking. However, most of these topics that are the subject of either proposed or final rulemaking are also areas that the SEC is covering right now under its current rule set. And so I think it's important to keep that in mind. But with that said, I think we'll turn to you first, Laura. I think just to get a good understanding of what we're seeing in the cyber threat landscape and like why do we care? I guess that's sort of underpinning all of the rest of our discussion.
Sure. So as the Chief of National Security and Cyber in the Northern District of California U.S. Attorney's Office, I work daily with the FBI. And I say that just to provide a sort of a framework for what I'm going to cover in the threat landscape overview. And so I'm going to give you some sort of statistics that the FBI has that uses when we go out and talk to companies. And by the way, the FBI will come talk to you anytime you want. You can just give them a call, and your local cyber agent will come do a presentation that will spell this all out in more detail. With that said, let me just share sort of the cyber landscape as we see it from the government's perspective sitting here today. First of all, cyber for us sort of means, it definitely means intrusion within the meaning of 18 United States Code 1030. So that's the unauthorized access statutes. That's what we use as the government to define a cybercrime. What I can tell you now is that the FBI reports by far that the reports that it gets from individuals and corporations, the number one threat is phishing scams. I think you all probably know, so I'm probably stating the obvious, but phishing scams in general are email or phone calls or something of that mechanism designed to fraudulently induce someone to give over their credentials, usually their passwords. So in 2023, I think there were about 300,000 reports of phishing within sort of the broad scope of phishing reported to the FBI. I asked the FBI to check, and as of now, it looks like phishing is on the rise, which is consistent with what we've seen over the last few years. This is speculation, what I'm going to offer you, but I think one of the reasons we see phishing on the rise and becoming ever more successful does have to do with the use of AI. We expect, and I think in the future, we'll actually be able to see statistics that bear this out, but that use of artificial intelligence, specifically chatbots, will enable cybercrime actors to more convincingly induce people to commit crimes. The grammar errors that alert all of you might not alert you to now that people are using AI. So at least in theory, this is one way that we could see AI being used by cyber criminals. The most costly to businesses, the most costly cybercrime that we see continues to be business email compromise. It also still evades law enforcement. It's an area where we really haven't had good tools to really disrupt and dismantle those networks. And then lastly, what I would say is ransomware is the number one priority for the department in the cybercrime context. It's an area that is so big, for reasons I'll just touch on in a moment, that we really have not been able, well, let me take a step back. So ransomware has really become a cyber criminal enterprise where we see a thriving business. We see you can buy the ransomware. You can hire the ransomware actors. You can buy the malware. You can buy the people to launder the money that you get. And so we see a really thriving criminal enterprise around that, which makes it very hard for us to disrupt it. However, I think the news is good in that the government has worked really across all areas and used all of our tools, especially with our foreign partnerships, and really been impactful in the ransomware context. But my sense, Kristin, to sort of the takeaways is that I think this will be an area that we continue to see really touching on all of our companies. And when I say ransomware, I mean sort of the traditional ransomware and also stealing your data and extorting you even without a ransomware demand. So I'll pause on that. I think that's a quick threat landscape. But I do invite people to contact the FBI to get a more detailed landscape briefing directly to your companies.
That's really helpful. No, thank you so much, Laura. And I think we'll switch gears and we want to talk about just some of what we're seeing, I think, on the enforcement front with the SEC in the cyberspace. And then we will switch gears and talk about the rulemaking as well and sort of what the impact is going to look like, as we can kind of predict it from there. But can you give us a sense, Lauren, of what we're seeing? Especially we've seen cases that are very high profile, like SolarWinds, which I know was touched on, and there were cases not only in the SolarWinds context that were brought against the company, but against individuals. So the chief information security officer was sued as part of that action. And then we've seen a number of cases over the years with broker-dealers and investment advisors. And I think it would just be helpful, how are you advising clients and what are you seeing in terms of takeaways? And what are you hearing? Because I know that you're hearing from some of your CISO clients, around some of these issues.
Yeah, so as Kristin was saying, we thought it might be helpful to talk about some actions that have happened with the existing rule landscape before we kind of roll into how some of those rules like Reg SP have been updated last week, or some, entirely new rules that seem to touch on a lot of the same things. So, I'm expecting that everyone in this audience is probably very familiar with SolarWinds, but just to make sure we're all on the same page, they were a software company that was the target of a massive 2-year cyber attack that, involved one of its marquee products. They disclosed the attack in an 8K in mid-December of 2020. Their stock price fell by 25% in 2 days and by 35% by the end of the month. The SEC has brought charges against both the company and the CISO that they knew about the vulnerabilities that enabled the attack, that they overstated the company's cybersecurity practices, understated the risks. And the statement at issues include both the filings and also the security statement on the website. And they've been charged with violating the anti-fraud provisions and reporting and internal controls provisions, which, sort of all things that we would have expected, but for the CISO being personally charged. The oral arguments in the motion to dismiss were last week on May 15th. It was 2 hours of arguments. It's a 90-page transcript. If anyone's looking for weekend reading, it's actually very good and interesting. They get into lots of nitty-gritty. Everybody was very well prepared, including the judge, so it made for a really excellent discussion. And, right at kicking off the arguments, the attorney for SolarWinds, talked about the deep policy implications and, raised the fact that there was all these amicus briefs filed at the motion to dismiss phase, which is, fairly unusual. In terms of takeaways, I had a friend who's a colleague that was at the RSA conference earlier this month, and he said that he was really taken by how interested the CISOs were in understanding 10b-5 and all the securities laws. And we had kind of an interesting discussion around the idea that, all human beings have sort of limited mental bandwidth, and do we really want our CISOs trying to understand security disclosures laws, or would we prefer them to be focused on sort of their core mission of deterring and detecting cyber threats? So, I think that that's one takeaway, although, Kristin, I think you've heard elsewhere that, it's not open season on CISOs and they need not be so worried, but...
Yeah, I mean, I'm hopeful that that's the case. I'm hopeful that it's sort of akin to, I think even saying those words, though, are not always going, to provide a lot of comfort for people who are sitting in that seat. And so I think it's similar to the discussions that we've had with chief compliance officers over the years, that when the commission brings an action against a party that is like a chief compliance officer or a chief information security officer who aren't necessarily involved in the fraud, it can have a very, very much a chilling effect on people wanting to take those roles. And so, I'm hopeful that it's not open season. I think we've heard the SEC say that, but it doesn't necessarily bring a lot of comfort, I think, to people who sit in those seats.
Right. And you don't want the people in those seats to be distracted or, anxious. You want them to be focused on what they should be focused on. So,
yeah.
I don't know, Luke, did you have something you wanted to say on CISOs before I went into broker-dealers and investment advisors? Or
I was just more nodding my head in that CISOs definitely need more support in that sense, and definitely a challenging time for them in the sense that they're having to turn on new muscles that they may not have used before, or relying on other resources to help build the divide between them focusing on countering the threats, managing risk, but then starting to switch their brain in other contexts, not just with cyber. We know that, they may take a very engineering-like approach to materiality, as an example, and that can have a whole host of other set of outcomes that in certain cases may not be cost-effective, may not fully consider all the compliance issues, but makes it very challenging for them when these new sort of issues arise.
Right, that makes sense. So another area where, the SEC Enforcement Division has, spent more than a decade bringing cases under existing rules is with respect to registrants, to broker-dealers, investment advisors, the exchanges, with respect to Reg SP, Reg SID, and Reg SCI. Like a Dr. Seuss book trying to get all of those out at once. It's reminding me of reading to my son's preschool class earlier this week. But, in 2019, 2021, 2022, we saw nearly a dozen household names in financial services subject to orders alleging violations of Reg SP and Reg SID. And, these were organizations that had very, very good cyber and data security programs, but nonetheless, there was a gap or a misstep. It was identified in an exam and referred to enforcement and ended up in an enforcement order. So, I think that speaks to the fact that this is hard stuff to do well, and even really well-resourced organizations sometimes come up short. A couple, takeaways from those is, the first two are kind of obvious, but I'll say them for good measure, is to design cyber procedures to fit the business model and review and update the procedures regularly because the threats evolve. But the other one that, was a consistent thread through a lot of those different events was vetting and overseeing and continuously independent contractors and third-party service providers. So a lot of the policies and procedures were excellent with respect to employees, but found gaps with respect to vendors or third parties or independent contractors or contractors that sort of came and went. And another piece was that seemed to be a consistent thread was also with respect to training. So having really good policies and procedures, but having the training not just talk to employees about what's the procedure, but how they are personally expected to implement the procedure. And then also reconciling procedures amongst affiliates to ensure consistency across the enterprise, which brings me to the most recent case of yesterday against the New York Stock Exchange, against ICE, 9 affiliated ICE entities, including the New York Stock Exchange, which was they were fined $10 million for a violation of Reg SCI. And I think it's really interesting to understand the cadence of events that led to the incident, because I think for a layperson, it was a really impressive timeline. And from a common sense perspective, it seems like they did a good job. And, that's not the SEC's point of view on it at all. So just to quickly go through it, April 15th, 2021, ICE learns they have a potential intrusion. April 16th, they determine that they do have an intrusion with respect to one VPN device. They work through the weekend to Tuesday, April 20th, with a bunch of experts they quickly brought on board, determined that it only impacted the one device and didn't have any other impact. They report this to their legal and compliance colleagues, who look at it and determine it had a de minimis impact and, make an internal notation that they'll report it on their quarterly reporting. Then April 22nd, 2 days later, the SEC calls and said, hey, we would have expected to have gotten a report from you on this. You had an obligation within 24 hours of the intrusion to report this. And that's how they ended up with a $10 million fine. So Reg SCI is is very prescriptive. And and Kristin, I think you said you remember seeing the alert.
Well, so I think with Reg SCI, there has been, it's been in place for a number of years now, and I think there is an expectation that registrants are going to, or that, folks who are subject to it are going to report quickly, timely. They're not going to make their own determinations about what is or isn't material. But it is sobering when you kind of run through that timeline and how quickly it happens. And I think there are concerns, when you see a case like that, even for, public companies or registrants who, with the pending rules that will require notification to the commission, I think that does probably strike some fear that even if one is thinking that something isn't material or doesn't rise to the level of materiality under the issuer rules or under the proposed rules for advisors, that there may be a sense that they need to over-report. So.
Oh yeah. Well, it's funny with storylines like that. I feel like a lot of lay people or even colleagues, legal colleagues that aren't in this practice area will say sort of like, that seems very technical, but like a lot of SEC enforcement cases are about technical things, even if nothing bad happened.
So Luke, I think you also had a perspective just on, SCI reporting and the NYIC case that came out yesterday.
Indeed. And I'll preface a lot of this for those of you that might be new to it. Some of the disclosures are a fairly new occurrence. I believe it was in December when some of the SEC cybersecurity rule dynamics went into effect, particularly around disclosures. And so since that point in time, we've got new visibility into one, certain public companies that have had cyber incidents, but then two, how they're sort of either interpreting what and how they need to report different information about those cyber incidents. And I think they're kind of telling in a variety of contexts, and we can glean some data points. I think at an overarching level, some are taking a very cautionary approach in terms of how they're following the rule. An example we saw, and it's sort of note too, First American posted at least 3 different disclosures in the month of December. They interestingly, as sort of a data point, had an enforcement action upon them sometime in the last 3 or 4 years, I believe. So they unfortunately have some experience in this regard. But there was really sort of a breakup of their incident reporting. Firstly, they acknowledged or disclosed that they had an incident. Secondly, they followed up with another disclosure, essentially noting that they've been taking mitigation steps and the incident had been contained. And then finally, they noted, and this was all in the course, I think, of about a month and a half, they had 3 disclosures. The final one was more of the getting into aspects of what was the impact, what were the exposures, expenses, and some determination around if it was material or not. And now we've already seen some maturity in terms of some of these disclosures where some victim organizations are combining more of these attributes together in a short amount of time. I spoke on a panel a little over a month ago. It was actually the incident response forum related to this, where there were other SEC cyber representatives on that panel. At that point, maybe there's some dimension of that with ICE, but there really hasn't been a lot in terms of post the rule going into effect in December. A lot of visibility into or follow-on guidance in terms of how cautionary organizations should sort of be or not in some of their disclosures. So I find that interesting. But I think we'll continue to see that evolve after hearing the director today. I think it'll also be interesting longer term if we hear other aspects about remediation also coming out of that, in terms of some of the, many of the disclosures mention unauthorized access. Many mention that our IR plan and our business resiliency went into effect. But generally there is a vulnerability or a control weakness or failure. So we'll see how some of those may or may not evolve longer term and speak to aspects of remediation. And I think just to sort of add a few other anecdotal points, by virtue of how we're helping firms, I'm oftentimes sitting in sort of an augmentation sort of assistance role for CISOs, or even an integration point between the investigation and oftentimes what in-house or outside counsel are doing to advise firms on what the disclosures should actually be. And I'll just generally say that, between that and some other interactions that our clients are having with the SEC, elements that are very important include visibility into what they knew and when about the incident. And so that speaks to some of the earlier dynamics I mentioned in terms of the disclosures, aspects of that their IR plan went into effect. And we'll probably talk a little bit more, perhaps in the broker-dealer context, around incident response plans and dynamics. I think there's a nuance too around that piece, particularly with SolarWinds, in terms of where the CISO function integrates in with some of that disclosures dynamic. And I think where we're going to see some of that continuing to mature is where that intersects with sort of the data breach or the incident response plan of organizations. But generally, just higher assurances needed across the board in terms of what organizations are needing to communicate, and just the overall visibility to the incidents themselves.
Yeah, no, and I think that was really interesting, and I don't think I prefaced my question quite right, but just to be clear, so you were talking about some of the issuer incident reporting that you've seen in light of the issuer rules that went into effect in late 2023, so that was super helpful, really good context. And then just stepping back, Britt, maybe you could just give us like the 30-second or 2-minute highlight
Sure.
just on what those rules put into place for issuers.
The issuer rule imposes a periodic reporting requirement as well as a current reporting requirement. So basically it's an overlay of cyber incident reporting on top of 8Ks and 10Ks, and the forms were actually amended to account for this. So in the event of a cyber intrusion, which has its own, cybersecurity incident, which is defined in Reg SK, an entity has 4 business days after determining that there was a material cybersecurity incident to disclose it on an 8K. And so the timing there is crucial, but importantly, it's not from 4 days from the incident, it's 4 days from a materiality determination. But the commission's made very clear that gaming those materiality determinations will be problematic. The release indicated that firms should be focused on the normal policies and procedures and timelines they use to convene meetings and do the sorts of things that would be necessary to determine if there was a material incident, and they shouldn't take steps to hold it back. But what has to be disclosed on that initial 8K is just the nature of the event based on what is known at the time. There's a mechanism for amending the Form 8K later as more information is learned, but that amendment timeline is also on a 4 business day track from when new information is learned or new determinations are made. But the purpose is to put out in the market that a significant event has occurred with as much information as possible. But there are also limits on what the commission's requiring. They're not requiring technical details or anything that could give threat actors insights into how they're remediating or what their vulnerabilities might be. And that was a significant change from the proposed rule to the final rule to account for concerns that people had about that. And the materiality standard is the same standard, basic Levinson TSC standard that we're all used to in the securities context. So essentially, this is not anything new, except it's made explicit that if you have a cybersecurity incident, you have to make an 8K disclosure that contains specified information. There is a national security and public safety exception that is interesting, but I think it will be little used, and Laura can speak more to this. But if there is a substantial risk to national security or public safety from disclosing that there's been a cyber incident, the U.S. Attorney General can, in writing, tell the SEC that the disclosure can be postponed for up to 30 days, and then there are significant timelines that can be extended beyond that, up to 6 months or even beyond that with an exemptive release. But I think the important thing to keep in mind is most incidents aren't going to rise to the level of needing that exception. And you have 4 days to get the U.S. Attorney General to write to the SEC and say you shouldn't have to disclose. So you have to be very dialed into what that process is going to look like ahead of time. And I know Laura can speak more to that. The second aspect of the cybersecurity rule was just normal 10K disclosures about what the risks are that a company may be facing in the cyberspace, what steps they're taking to mitigate and identify and assess those risks, and who's involved in the process and planning and the various steps that the company would be taking. So it's very much like what companies are disclosing already. It just has a very specific set of requirements in the cyber context. And I know earlier today there was some talk about Regulation SP, which is for covered entities like broker-dealers and advisors who have personal financial information from customers, and they have a very specific timeline under the Reg SP amendments for disclosing incidents that have given access to or have facilitated the use of personal customer data. And they have I believe, a 30-day time frame for making those disclosures. So the upshot of this is the SEC is making explicit what it was expecting companies and broker-dealers and advisors to do already, but now there are very specific guidelines in these cybersecurity rules and Reg SP amendments on exactly how these disclosures are supposed to be made.
Thanks so much, Britt. And I'll just ask Laura very quickly. So are we seeing a lot of exception requests on the 4-day timeline?
We're not. And the only point there is that if you want to trigger the Attorney General's recommendation to the SEC, you go through the FBI. You can report to U.S. Secret Service. You can report to CSED. They're going to go to the FBI. So I'll bring it back to my theme, which is have a relationship with your local FBI office. It will make things faster.
That's great. And Britt, Lauren, do you want to just talk briefly just about what you're hearing or what you're seeing for broker-dealers and investment advisors?
Yeah, so I think, obviously the cyber rules for the issuers are in effect that we talked about. The Reg SP amendment came out last week. That leaves sort of on the table two proposed rules, one with respect to investment advisors, investment companies, and BDCs, which was actually proposed before the rule for issuers was proposed. It was proposed in February of 2022, but it still hasn't been adopted. It actually had the proposal for the investment advisors, investment companies, and BDCs, and the proposal for the amendments for Reg SP they were a little crossways with each other. So since the Reg SP amendments have come out first, we expect when the final rule for investment advisors does finally come out that it'll sort of have cleaned that up. But the Reg Flex agenda says that we can expect it the first half of the year, which would mean in the next 6 weeks. But it has also said that we could expect it for the last year, so I want to hold your breath. And then the other corresponding rule in terms of cyber is for broker-dealers, clearinghouses, MSRB, FINRA exchanges, transfer agents, major security-based swaps participants and security-based swaps participants, dealers, and repositories. So that rule was only just proposed last year in March 2023. It is also on the agenda to be finalized in the coming months. So we will see. But if they do, then they will have, sort of covered the entire vast landscape with new cyber rules.
Great. And Luke, how should folks be preparing for these rules? I know the issue rules are in effect, for public companies, but what about for, the myriad entities that Lauren just noted?
Sure. There are really kind of 6 key areas as I'm tracking with them. It speaks to incident response planning. I think that organizations should make note that includes aspects of communications, and that flows into that 30-day notice dynamic that was mentioned. There's a specific call out to service providers, so third parties, noting that broker-dealers are oftentimes in that ecosystem highly reliant upon third parties to fulfill some of the systems and or customer experience and service delivery. So it's notable that those broker-dealers need to, they'll need to have some extension of their overall risk management and assurance from that vantage point. Safeguards and disposal. So that means that speaks to aspects of not just the controls, but then how the controls also are disposing of key information, which is of note. There's been common occurrence of essentially victim data exposed that probably shouldn't have been by virtue of not having sufficient data deletion and so forth. And then the aspects about the record keeping, which has already been talked about in terms of the documentation around policies and procedures. There are, just out of personal experience, certain broker-dealers that aren't as mature as some of the larger ones. And it can become a challenge for them, especially if they're essentially subscribing or buying templates for their policies and procedures. And it's really dangerous to have procedures, obviously, that you're not necessarily following. And then the privacy notice piece, which I'd probably defer to Counsel to kind of speak to those dynamics. But in terms of key practical takeaways that I would just sort of mention this dynamic is, you got to be aware of where your data is, your consumer data especially. And I think the SEC's bar is likely to increase as we've seen with other regulators, because we're also working with NYDFS and others that have been very sort of avant-garde with cybersecurity issues. And not knowing where your data is and the risk management around that, it still comes back to that. And so firms that have surprise, or back in the day we'd call it sort of phantom or vampire data in terms of how it comes back to cause you trouble. I think that the cohesion between security risk management, needs to be tightly intertwined with data, but obviously all the rules that we're seeing here.
Yeah, no, I think that's a really good point. And even though there isn't an explicit data classification requirement in the proposed rules for broker-dealers and advisors, you really do, to your point, you need to know what you're protecting. And so that kind of, argues in favor of having that kind of data classification in place. And I think there will be a lot of expectations that come into play when and if those rules are finalized, maybe in the next few months.
Holding our breath.
Holding our breath. And we're definitely seeing, I think we're definitely seeing in the exam program, which often serves as kind of a feeder for enforcement in the advisor and broker-dealer space, that there's a focus on cyber. And one important thing to note is the sole deputy director in the exam program right now, Keith Cassidy, shares 2 hats. He also runs the technology controls program, which is, runs really the more sophisticated cyber program within the exam group. And so we're starting to see, kind of more sophisticated folks appear on exams that are cyber focused. And that's not surprising, given, I think, Keith's kind of focus. And so I think, we are seeing a level of sophistication for advisors and broker-dealers in terms of the questions that are being asked. We're going to switch gears, and in the last 10 minutes, I think what's notable, we are not going to go through the hundreds of pages of adopting release disclosure on the climate rule and the private fund advisor rules, because it would take us all day and it would be very, 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 very boring. But I think what is, very interesting about both the climate rule that was passed and finalized by the SEC, as well as the private fund advisor rule, is just all the litigation around the rulemaking. And it's kind of at an unprecedented level. And So I think that's maybe the more interesting part of the story in our last 9.5 minutes.
Yeah.
And so it would be great, Britt, if you could, maybe just kick off and give us an overview of some of the challenges that the SEC, in terms of the private funds rule as well as the climate rule, some of the challenges that the industry has brought against those rules and the grounds.
Sure. So both rules, the climate rule and the private fund advisors rule, are both facing challenges in various courts of appeals in the U.S. The climate rule was enacted within the first 10 days. 9 different lawsuits were brought challenging it. Petitioners filed for review in multiple circuits across the U.S., and now the case is consolidated in the 8th Circuit. And that's being the panel and the specifics of it. I think they now have a briefing schedule according to Laura. But basically, it's a challenge to the SEC's authority to enact the climate rule. And it's sort of teeing off of some of the more recent environmental protection regulations that have been struck down, like the Clean Power Plan, the idea that the SEC doesn't have the statutory authority. It's an investor protection financial performance agency, and now it's in this business of trying to regulate climate disclosures. So that's the substance of the challenge, is that the SEC shouldn't be doing this. How it's playing out legally is it's an Administrative Procedures Act challenge, that the SEC acted arbitrarily, capriciously, and without substantial evidence. There's also the major questions doctrine in play, that this is an area that Congress didn't intend the SEC to be involved in based on the history of the agency and its purview, that if Congress had intended the SEC to be doing climate-related work, it would have specifically authorized that. So I think the challenges are hoping to gain on the momentum that the Clean Power Plan and other environmental challenges have generated around this extension of an agency's authority. So it's very much this overreach of agency power that is seen in a lot of recent rule challenges. Relatedly, the issue is whether the SEC can demonstrate that there is a financial nexus or there is a company performance nexus related to these climate disclosures. The agency is taking the position that investors care about this information because the climate issues can impact the way a company performs, but whether there is the substantial evidence the agency needs to support that remains to be seen. But that case is underway. I think Laura said the briefing is supposed to be completed by September. That may not be the end of the line. Obviously, the stakes are high in a case like this, both for the agency and for the trade associations and groups that are challenging it. So my expectation would be once there is a ruling, there will be a petition for rehearing en banc before the 8th Circuit, and then a petition for cert potentially based on whatever the outcome is. The private fund advisors rule challenges are substantially the same. They're APA challenges, they're major question challenges, but the statutory issues in that case are a little bit different and a little bit more interesting. First of all, the question is there one rule or is there 5 rules? The agency is taking the position that there are several different rules. The people challenging are taking the position that it's one rule. Obviously, that makes a big difference in terms of what stands or falls. But I think the thing that's most interesting there is because that case has longer term implications for the SEC's rulemaking power. The SEC relied on a Dodd-Frank provision that the challengers are arguing relates only to retail investors and shouldn't be used to go into a totally different private fund space. And the SEC also used the anti-fraud provisions of the Advisors Act, which is raising another substantial evidence type of question because the evidence that is in the record relates a lot to settled enforcement actions. And this is something that as an SEC alum, the settled enforcement actions being used as precedent has always bothered me. So I think this is an interesting way for that issue to be teed up. But that case, the parties had asked for a decision by May 31st. Whether the Fifth Circuit complies with it or not remains to be seen, but there will probably be ongoing litigation. And the rule implementation for private fund advisors has not been stayed, but the SEC did voluntarily stay the climate rule.
Thanks so much. A lot to unpack. And I think one thing that was interesting is for the private fund advisor rule, the oral argument is actually available online, and it's relatively interesting. And
I think it's very interesting. My colleagues, Jean Scalia and Helgi Walker, are argued both are looking forward to arguing climate and argued private funds back. Jean argued private funds back in February, and yet you can listen to all 40 minutes. It's very interesting and very telling, although Jean would say it's even more telling if you could see their body language in the room. So I think obviously we feel good about the strength of the case and are waiting. We're very excited. We hope that the decision will come May 31st, as you said. No guarantees, but it was part of the motion for expedited review, and the motion was approved. So we're hoping that we'll have our answers the next week or two.
Yeah, and I think one question that we're getting a lot is just what are the range of outcomes from the litigation? So what will happen? If the rule is struck down, that I guess that's one approach.
Right.
But give us kind of the lay of the land, Lauren.
Yeah. So the court could knock out the rule in its entirety based on a number of different reasons. It could look to the source of authority, as Britt was saying, using Title IX of Dodd-Frank rather than Title IV, which is the section that is specific to private fund advisor registration. Other broad-based arguments for throwing out the entire rule would be the lack of factual foundation, so that the petitioners argued that the SEC failed to point to a real market problem, that evidence that a rule was needed to address. And so, that would obviously be textbook arbitrary and capricious. In talking about these rules, if the happy hour had already started, we could make a drinking game of arbitrary and capricious as you read through these briefs. It's like arbitrary and capricious, arbitrary and capricious. The other reason it could be knocked out on broad base would be that the SEC had an obligation under the Advisors Act and the Administrative Procedure Act to conduct an economic analysis, and the petitioners contend that the analysis put forth by the commission was deeply flawed. But, in addition to knocking it out entirely, they could remand it without vacating. The Fifth Circuit did that before in the share repurchase rule case, but the SEC missed the deadline, and so the rule was vacated. We don't expect that outcome here because that, if it was remanded, it would be because the SEC could resolve the issues by sort of explaining it better, and the issues that have been, the errors that have been brought to bear by petitioners, don't seem like that would be an expected outcome. And then the last would be to vacate just parts of the rule. So in the oral arguments, when it seemed like the attorney for the SEC was really leaning into this fact of that the petitioners had focused on specific examples in the rule, and so perhaps some of those specific examples, the court might decide to vacate some of those specific examples without throwing out the rule in its entirety. So those are sort of the broad range. They could throw it all out, they could remand and vacate, or they could throw out just certain parts.
And I think we're all reading tea leaves in terms of which parts of the rule that we think could potentially, or rules that we potentially could be thrown out. One ground to throw it out would be that the SEC did not do an adequate cost-benefit analysis. And I think given the importance of the private fund advisor rule and the climate rule to the chair's administration, and his legacy, I would not be surprised if the commission doesn't have a cost-benefit analysis in the works or ready to go on some of these portions of the rule.
Right.
We're now down to the last few seconds, I think, of our panel, and maybe in the category of other topics. Laura, I could turn to you for just a minute, because when Izzy was speaking earlier today, he mentioned that IP cases are really kind of a hot topic and a big priority for the office. And so maybe connecting it back to securities a bit, but over to you.
Yeah, I mean, sure. Just very briefly, Izzy did, I think, I wasn't here, but I think he said IP is a priority. It is for the whole department. The department's very focused on protecting intellectual property, making sure it doesn't get into the hands of nation-state actors whose interests are not aligned with our own. So it remains a priority. And I will say, as I've been listening, I've noticed one interesting thing, which is from the DOJ perspective, in sort of the cybercrime and intellectual property context, companies are really situated as victims, which is not necessarily the case in the SEC context. And that's zero. right there.
Nailed it.
And we haven't gotten the hook from Bruce yet, but I expect it's coming. So, and happy hours outside. So we will stop and thank you so much to the panel.